If paper alone could talk, then William Mason, Terence and Kieran Fernandez, Ashton Vanegas, Ernest Henry Castillo, and Ryan Rayburn would be convicted many times over. But the papers and other items handed over by Police Prosecutor Chester Williams at today's preliminary inquiry before Chief Magistrate Anne-Marie Smith are only part of the story. The rest is up to the more than 20 witnesses who gave those statements to police and who will be asked to stand behind them in the Supreme Court. It's why both defense attorney Richard Dickey Bradley and Williams, at a case status conference 2 weeks ago, both seem to look past this day while restating its importance.
I informed the Chief Magistrate that we will not be wasting time, that the law provides that once there is some evidence, they use these Latin phrases, prima facie and so on, once there is some evidence in the file, it's not a trial, the procedure is that if there is some evidence in a file against an accused, the attorneys can make submissions or they can save that until when the trial gets underway. Trial is the proper place for that matter.
I am not the person who will decide the outcome of this case. So I'm not in a position to answer that question, but I can tell you that as an attorney and as a person who is dealing with the matter at the magistrate court level, that there is sufficient evidence in the file against the other defendants. And that is the reason why the DPP did not direct that charges be withdrawn against anybody else.
Bradley and fellow attorney Oscar Salgado were away from the Chief Magistrate's courtroom today, leaving Mason and his fellows to face the music alone. Apart from the paper's statements and reports from the scenes of crime technicians and coroner Dr. Mario Estradaban, there are two key things police are hanging their hats on: DNA from the blood found at the crime scenes and video surveillance. Williams explained the significance of both.
So in the case of those tests that were sent abroad and the ballistic tests, would they be available in time, the results in time in terms of the trial?
Well, we are hoping that they will be. We have sent them, and by our indications, we believe that it will be in the country by then. The case had been committed to the June session of the Supreme Court, so I believe we have sufficient time to be able to get the evidence back in the country for them.
Sir, we noticed that the Chief Magistrate placed stress on the video evidence that you all provided. You're able to confirm that that is indeed part of the evidence and it is something that will be relied on?
Of course, yes. We have a video surveillance tape that the prosecution will be relying on at the trial in respect to this matter.
Relying heavily upon one of the key exhibits.
I'm not going to say heavily, but we'll be relying on it.
There is a caution statement from one of the defendants and video interviews with all of them except for Mason, who invoked his right to remain silent under the law. But one thing expected to come out at trial is information about who he really is.
There were some documents, I am not sure if I'm correct, but banking information from Canada to here, or?
Well, those are things that the police did to have been able to establish the true identity of Mr. Mason, and those documents will be relied on as well to show who William Mason truly is.
So can you say who he truly is at this point?
It has been said in court, the documents are there.
Okay, and also there were some in relation to companies that they established here in Belize?
Yes, the company established by Mr. Mason, and
Just
again,
one?
the documents pertaining to those companies, the article of incorporation and so forth will be relied upon to show the company and who the directors of those companies are.
But even without the DNA, Williams and the DPP's office believe they have a case beyond reasonable doubt. Sometime after June of this year, they get to tell it to the judge. Aaron Humes reporting for News 5.